Talking about it, he's a relatively young substantive minister, and we'll be finding out his approach to the Attorney General's office. Also, you can join us on social media as this program is streaming live. It's Metro TV Ghana on all platforms. We'll be right back after this break.
Vehicles for everyday movement. Contact us on 000-0831 or 054-555-7500. You can also email us info@saautomobilegh.com or visit our website at www.saautomobilegh.com. SA Automobile, the pleasure of doing business with you is all ours.
Ghana is a beautiful country. There is so much of it you probably haven't seen, haven't experienced, haven't touched, haven't felt, haven't eaten. When this is all over, let's discover our land again with new eyes. Let's feel each other again. We are one people, brought together by destiny. Let's make that count. Let's show love for each other and our environment. Let's tell our stories, and let's watch and listen to our stories. There'll be so much to tell. Ghana is a truly beautiful country. Be Ghana, stay in Ghana, experience Ghana, make Ghana great. And we'll invite the world to come and experience Ghana too. But for now, stay home. Brought to you by the National Film Authority. Support the Stay Home and Discover Ghana Later campaign. This channel supports the campaign.
God bless our homeland, Ghana.
So my guest is the Minister for Justice, also Attorney General Godfred Dame. Good afternoon to you and welcome to Good Afternoon Ghana.
Good afternoon, Francisca.
How are you?
I'm not too bad, and you?
I'm good, and you look good. I like your spectacles.
You're telling me.
Looking younger by the day.
Great.
I want us to start with your time in office as substantive minister. Not so long ago, I think in January. How has it gone for you, moving from Deputy Attorney General now to substantive minister?
I think there is a material difference to 2017. The difference is that our administration has had the opportunity to govern for 4 years. A lot of projects have been initiated, and also there were a lot of cases already pending, and those cases have been either determined or have been continued. So really, it's a continuation. There has not been enough room for one to say one is having a holiday. Definitely not us compared to say 2017 when there was some kind of grace period, some period that the government will be given opportunity of settling in. So we have had to hit the ground running, and that's how it has been. So right after I was appointed, 5th March, one major decision that I took was to, in spite of the fact that the judgment had already been given against the government of Ghana in respect of this GPGC contract, the judgment was given, and that's in arbitration proceedings, we call it the award. But it's the same as a judgment.
Okay.
So in ordinary parlance, the judgment had already been given in January 2021. And there had been the lapse of an extension of time within which to appeal. I took the decision that, notwithstanding the lapse of time, we could go the extra mile. The extra mile was to file a challenge, to file an application for further extension of time to file a challenge. So I took the decision right after I was appointed. My first working day was 9th of March. Because the 6th of March, statutory holiday in Ghana, but of course it was a Saturday. So a statutory holiday then fell on the Monday, 8th of March. And that's the same day that the extension of time that the government of Ghana had been granted to file the challenge, if any, was going to lapse. It lapsed on the 8th of March, and I reported to work on the 9th of March, and I instructed the barrister in London that notwithstanding the failure of the previous lawyers of the government of Ghana to file a challenge, we also ought to at least test the situation by attempting another application for extension of time. And that is what was declined by the High Court. And somehow people have mischievously interpreted or misinterpreted it to mean that it was my administration which defaulted in filing an extension of an application within the time given by the High Court. At that time, the first period given by the High Court for the Ghanaian government to file an application, if it required or if it desired, 8th March. The order was given way back in February. I was not in office. I was not at danger at all. And
why is it important to make that distinction?
It is because of the headlines that have been given. It's important that people ought to know the proper set of facts and to set the matter in the proper context. Okay. And indeed, that is actually the reason why some media entities called me, because the allegation...
Including us.
Precisely. So we ought not to shy away from the fact. The allegation was that I had defaulted. I mean, the default occurred before I assumed office as Attorney General. Okay. And of course, when I assumed office as Attorney General, I decided to go with the extra mile. So any step that I took was actually an extra mile for the government of Ghana. I was trying to actually assist the nation to attempt a possible challenge. Okay. And that is what was declined. So the horses had voted already. And the horses had voted already. What is left to be done?
I want us to situate this case for the benefit of those who haven't followed. This started, what, in 2016 before your government came? This GPGC
right. Yes.
Contract.
Transaction.
PPA started with the former administration. That's the NDC.
Yes.
So maybe give us the trajectory.
Right. So I think it's quite interesting. So in 2015, the ESWA NDC administration entered into this transaction. It described it as an emergency power purchase agreement, EPA, and it was for the delivery of power to the state. The agreement contained certain conditions precedent, certain factors which would necessitate the effectiveness of the agreement. But in the same agreement, Clause 2 thereof stated that irrespective of whether the conditions precedent had been satisfied, the agreement would occasion consequences, financial consequences for the state. And that, for me, is absurd. It's totally contrary to all theories of law under Ghana law. Because really under Ghana law, a contract is effective only upon the attainment of conditions precedent. And therefore, the question ought to be asked as to why any administration will enter into a transaction which would result in financial loss being occasioned the government of Ghana, even when there had been a failure to satisfy the fundamental point of the agreement reaching effectiveness or the satisfaction of conditions precedent. So that is one. Now, the ESWA NDC administration, in addition to this agreement, had entered into multiple power purchase agreements, such that by 2016, it was anticipated clearly that there was going to be excessive capacity development and also onerous financial implications for the government of Ghana. So the NDC administration itself in September 2016 constituted what they termed as the PPA committee. It was a PPA review committee. That committee reviewed all PPAs that had been entered into by the administration, with a view to advising on the viability of same and the way forward, because they were saddled with so many agreements that they didn't know how to manage. So the committee came up with a report early 2017. Of course, government is a continuum. So even though the committee was set up in September 2016, when the NPP took office, it inherited the work of the committee. It allowed the committee to function, and the committee came up with its report. And that report decided that this agreement ought to be terminated. So the report to the PPA committee recommended a termination of this agreement.
This was in 2018? 2017, April, when the NPP was in office.
Yes, but that committee, it is material to note, had been set up in the previous administration. Because indeed, I think God works in mysterious ways. If that committee had been set up in our time. The allegation would have been that, oh, MPP came and MPP decided to terminate the agreement. We decided to constitute a committee for the purpose of terminating their own agreement. But they themselves, in the history shows, realized the onerous financial implications of the agreements that had been entered into, and the fact that most of them were unnecessary. Unnecessary to the extent that they would deliver excess capacity.
Very well.
And the nation wouldn't be able to bear. And that committee came out with that determination.
Let's look specifically at what was wrong with this, from what you gleaned from the committee's report. What was wrong with this contract, the GPGC and government of Ghana?
So the committee actually cited the high cost of running the machines. The committee also cited the fact that technically delivering power by GPGC under this agreement would be very much difficult. They cited the location of the facility and the practical difficulty of obtaining gas and what have you.
Okay.
So on account of all of these factors, and taking into account that ultimately between 2018 and 2030, excessive power supply will be delivered to a nation, the committee recommended a termination of this agreement. What the committee got wrong was their assessment of the cost of termination of the agreement. The committee, I'm saying legally they got it wrong because they indicated that the state could terminate for about 18 to 20 million. That for me was wrong because the agreement signed by the NDC exposed the nation to far greater loss.
Okay.
Clause 1 of the agreement identified, defined the effective date at the date on which conditions present will be satisfied. Clause 2A defined the term to mean the date from the time for the date of signature.
Okay.
Then Clause 2B indicated that irrespective of when the agreement is terminated, the party not in default of the termination will be entitled to all sums that are allowed under Clause 25. And that Clause 25 is where the problem was, because it actually entitled whoever was not responsible for the termination to be liable for payment of all expenses virtually the sum of running the contract if it had been discharged to its completion. Okay. So that is what I beats my mind. That is what I cannot wrap my head around, because indeed I can't understand why an agreement which had failed to achieve effectiveness or had failed to or conditions present had not been satisfied will render the government of Ghana liable for payment of all sums that the government would have been liable to pay if the agreement had been allowed to operate to its conclusion. Be that as it may, the point is that it became necessary for the government of Ghana to take a decision on these PPAs which were going to result in excessive power supply. Because the determination by that committee was also that if these agreements were not terminated, the state was going to incur losses of $586 million per year, and cumulatively was going to incur losses of $17 billion between 2018 and 2030. So between terminating some of them and incurring hundreds of millions, which of course Boakye Jarko, who was the energy minister then, indicated in his report to Parliament that yes, a decision had been taken to terminate some of these PPAs for a total amount of about $480-something million. That assessment clearly was more profitable than incurring the total loss of about 586 per year, a total of 17 billion over the period between 2018 and 2030. So I think those are the factors accounting for the termination. And the previous Attorney General, Madam Gregor, recommended termination of the agreement in 2018 on account of the PPA committee report. So her decision was informed purely by the PPA review report, and also an examination of other circumstances surrounding the agreement, i.e. failure to attain conditions precedent and what have you. And unfortunately, that determination was adjudged to be wrong by the Permanent Court of Arbitration, which we were subjected to. In any case, the fundamental point is that the termination was necessary. Secondly, relatively, the state was saved more losses.
Okay. So with the decision by the Court of Arbitration in London, what happens next? We've heard you talk about taking this up to the CID for investigations. Right. What is it that you want from this?
I think if you're a public officer, you're acting in accordance with the tenets of reasonableness, diligence and sound policy, you ought not to take any decision which will expose the state unnecessarily to financial loss. That is why there's a provision in the Criminal Offences Act for causing financial. It said willfully causing financial loss. And willfully causing financial loss is occasioned where a person takes a decision either recklessly, negligently, or deliberately with the intention that the state will ultimately lose. So the question must be asked as to why a public officer vested with discretion and vested with the nation's resources will enter into multiple PPA agreements which would occasion excess supply. Supply when the state was not in need of the power, and also at cost that was adjudged by the PPA committee to be excessive. There must be an inquiry into these matters to ascertain whether the acts of the public officers were deliberate, reckless, or just negligent. And if that is the case, then of course the penal implications will follow.
So then what you are pursuing now will be criminal?
Essentially, yes, because the CID deals with criminal proceedings.
Okay.
So it's just an investigation which will form the basis for possible charges against public officers culpable in the whole transaction.
Let me bring in another interesting thing. Well, it doesn't appear all gloomy,
right,
because there are other cases involving judgment debts that you say would save us or have saved us some money as a country.
Yeah, that is so, and indeed that is actually what we're supposed to do. Attorney General is supposed to act in a way to save the public purse when necessary. It's only when, after applying your reasonable skills and acting diligently, you're able to do so, no consequences will follow, because you did it to the best of your ability. The Office of Attorney General does not generate contracts. Contracts are generated from outside the ministry, and we only, when the public officers are in default, i.e. having terminated the agreement, we just go to their defense. So it is remarkable that, yes, you are leading to some instances of the state having been saved money as a result of our
involving the NDK.
Yes,
and
NDK, for instance. So
tell us how much you are saving us.
The NDK, for instance, we saved over 1 billion Ghana cedis. Was a transaction that I felt was very unreasonable again. Started way back in 2011 or so. Okay. Judgment was given, 2009 or so. Judgment was given against the government of Ghana, and on account of the computation of compound interest, the state was exposed to paying about 1.3 billion Ghana cedis out of a transaction which was just about 268,000 Ghana cedis. And I thought that was very absurd, unconscionable, and steps had to be taken to deal with it. I filed a challenge. Fortunately, the Supreme Court upheld the challenge, and just about 2 weeks ago, the Supreme Court indicated that the government of Ghana was just supposed to pay 14,000 Ghana cedis. And I think that's one remarkable saving. Secondly, in respect of these energy agreements that were unnecessarily entered into by the NDC, it's also important to place on record that there's one such arbitral award. It involved West African Gas Limited. Again, had to be terminated on account of the fact that they were all going to result in excess supply. And the company claimed $1.88 billion against the government of Ghana, an amount of $1 billion and 88 million USD was claimed against the government of Ghana. We fought it vigorously, just as we fought this GPDC, but of course we were not able to succeed in that one. The state was just compelled to pay $68 million. I think that's one remarkable saving that we have made. There are other instances that we are engaged in. There's this AT&T also judgment debt, trillion cedis, account of a default of a far lower amount. We're challenging that one as well, and I'm sure we'll prevail. So the position must be expressed that clearly this administration and myself in particular, I'm against judgment debt, and that I will pursue any public officer. It's just on account of the same principle that I'm referring the conduct of the public officers in question to the CID. I think that whenever any public officer, by his actions, occasion undue financial loss to the state, that public officer must
because I was going to ask that, would it mean then that if the civil approach is not successful, you're going to go pursue it criminally? in all of these cases?
Okay, civil approach in respect
because
of...
the London Court of Arbitration
Yes.
didn't allow the extension for the application.
Yes.
Wouldn't you have left it there?
No. If the London Court, you're quite right to understand, if the London Court had upheld my application and had ultimately heard the substantive application and had ruled in our favor, setting aside the award, there would really have been no financial loss. But of course, the acts of the public officers would also have been criminally, I mean, would have been placed in the criminal contest in a different way.
So you would have still pursued it?
I could have, because I thought that was really reckless, was unnecessary, and all.
Okay.
Yes. And I think all those who are trying to, with all respect, make noise about how the application failed and all, they know about efforts that are being made to pursue them in respect of other offenses. And I'm not going to disclose, but very soon, the next few weeks or so, you'll hear from the Attorney General accordingly.
Okay,
we'll be offenses that
be waiting.
were brought against public officers for the same acts, deliberate acts of causing financial loss in various transactions.
Let's talk about Fix the Country protests. These are people who say they are young Ghanaians, they're trying to protest about difficulties in the country. They talk about high cost of rent, they talk about unemployment. They want to do a protest. And this is under a president who is known for that. He's in the past led the Kume protest and everything. It would appear that the government would not want them to go on this demonstration.
Definitely not. I'm also for demonstrations. I've also led demonstrations. I'm on record as one of the founders of the Alliance for Accountable Governance. I led a demonstration all the way from Circle to the streets, TUC, ministries, and what have you. And I think I'm also in full agreement with the right to express oneself freely. The right to express yourself can be exercised through many means other than demonstrations. So demonstrations is really not the only way to express oneself. The substantive matter is before the High Court Accra. I wouldn't like to prejudice this. Safe to say that the restriction has been imposed by circumstances that we all know, COVID-19. There's nowhere in this world that demonstrations are allowed. It's only on account of spontaneous circumstances that people demonstrate. It's only on account of very compelling circumstances that people may demonstrate. So you take account of the Black Lives Matter. Very unfortunate incident, tragic, I mean, crude on all accounts, and people just spontaneously came out onto the street for weeks on end and had support around the world. What is the purpose for this demonstration? They claim they're going to, hold on, they say they are demonstrating on account of broken promises by successive governments. So that shows that really the demonstration
is not just about the NPP.
So the demonstration on their own showing, the demonstration on their own showing was on account, it's not about the MPP. It's on account of factors that have resulted since independence.
So allow it. It's not about
Hold on.
the
So it is
NPP.
not urgent. It's not pressing. If you are demonstrating about broken promises by successive governments since independence, what is the urgency about it?
The agency is
And in
that
any
they
case,
feel
are they
hopeless.
not also mobilizing through other means, social media and whatever?
But that's not enough.
Anyway, the matter is in court. Simple as that. So I think that I'll rest the argument
but
here.
for somebody who yourself, you've been involved
Yep.
in demonstrations, I'm surprised that you don't think it's
I think
necessary.
that, no, they actually indicated that they wanted it to be heard. So what did the government do? We acted in a manner that no government had done. In an unprecedented fashion, the government constituted virtually its top ministers in government to engage them on their concerns. I was one of them, the Minister for Defense, Minister for Foreign Affairs, Minister for Interior, Minister for Finance, and a few other ministers, also National Security Minister.
So was that engagement successful then if they're still persistent?
Clearly it was successful. When I was at the meeting, they actually refused to speak. And as when I left, they made a few remarks, and that was
Why?
it. I don't know why. So that tells you the motive perhaps is perhaps more
Is there some
mischievous
kind of
and deeper than you
Is there
think.
some kind of personal friction going on between you being singled out and them?
No, asking what?
So, and I'm asking,
Myself
why
as-
would they not
as the
speak
Attorney General.
in your presence?
No. I'm saying that throughout the period, I was there for about 1 hour.
Okay.
And when I left, the meeting last ended just about, I had ended just about
So
10
then it
or so
wasn't
minutes
successful.
after. Well, because they refused to cooperate, and I'm saying that when I was there, they refused to speak. And after all submissions have been made by the Minister for Interior, National Security, Defense, Foreign Affairs, what have you. So, Foreign Affairs actually was not there when I was there. I think she came later.
Okay. So the last time you were in court, in fact, it's also interesting to see that you were in court at some point or some points of this case.
Right.
I will link it to other cases where we've
Right.
seen your presence in court. That would appear to some people as a very aggressive, hands-on approach. This is a man who gets his hands dirty to do his job. Some will appreciate it like that. Others too will see it as sort of pushing back the police prosecution in this instance. Then,
I think that I'm hands-on if necessary. For the back rest with the Attorney General, I am the principal legal advisor to the government of Ghana. It is a matter of immense public interest, a matter that the president has deemed necessary to convene most of his top ministers, finance, trade, finance, interior, defense, foreign, to meet such ministers, such prospective demonstrators. And the matter has resulted in a court proceeding. What is awkward or what is absurd about the Attorney General representing
it shows that the government prioritizes it.
Precisely. So it shows that the government is actually concerned about them, and that concern was exhibited long before we even went to court by engaging them.
But the fact that we don't see an end in sight and we see everybody's going to court, there's a back and forth, then makes us question the priority that is being placed on it.
The government has no control over judicial proceedings. The judiciary is independent. So we went to court.
But you went to court to restrain them.
A very bizarre objection was raised by counsel on the other side that the Attorney General ought not to represent the police. This is a position that seeks to upset the constitutional order. Because that really seeks to overthrow the entire constitutional architecture that we have. If we say the Attorney General, who is supposed to be the principal legal advisor to the state, the one who is supposed to commence civil proceedings and criminal proceedings on behalf of the state, the one on whose behalf the police prosecute. All prosecution is done by the police on the fiat of the Attorney General. That same person cannot represent the police. What are we talking about? I think that there's so much mischief in all of this, and for me, it's very deplorable. Deplorable in the sense that on account of mischief spewed out to the unsuspecting public, people even enter the courtroom and make outrageous submissions. And I mean, how can you, a lawyer, contend that the Attorney General cannot represent the police service? The police service is part of the public service of Ghana. So the implication of that submission is to even say that when a policeman does anything, there are legal consequences out of it. The policeman is supposed to engage his private lawyer.
But perhaps because they've got police prosecutors. Because
the police prosecutors, as I indicated, basically, primarily, I mean, every lawyer knows it, or ought to know, are acting on behalf of the Attorney General.
Yes.
Article 88 is simple and basic that every first-year lawyer should do.
So why don't you let them act on your behalf?
Criminal prosecution is supposed to be initiated and conducted and controlled by the Attorney General.
So somebody will wonder why you don't let them act on your behalf and that you control from behind, but being at the front.
The situation where the Attorney General initiates or conducts proceedings in court is not novel. President Akufo-Addo, when he was Attorney General, used to go to court many, many times. Ayuko too used to go to court many, many times. Honorable Jogati, many, many times. So what are we talking about? If for one or two reasons there have been a few Attorney General who have not been going to court, that's what rather was novel. There cannot be a situation where an Attorney General never goes to court. It never happens.
You talk about...
Even my predecessor, Madame Grekufu, was going to court. Or you never saw Madame Grekufu in court? So what are we talking about?
You talk about, Mr. Dami, you talk about...
So there ought not to be any phobia about Kofi Dami should have in court, in all humility.
You talk about mischief going on, and you were subjected to some name-calling in court where you threatened to take up the matter, criminal contempt out of it. Question I want to ask, well, the young man hasn't stopped. He's continued to...
It's up to him. I've tolerated such abuses at my person much of my practice. I mean, right from when I was in opposition to government and all, even some people wrote various letters. Remember Martin Emily wrote some article, totally unfounded, alleging that I was behind the publication without supplying any basis at all in his article. I never replied. I ignored it. So really, it's normal. and I move on.
So you would dismiss it, essentially?
Well, I reserve the right to do so.
How long is government going with this case, Fix the Country and the Republic?
We are not going on with any case. The only application filed by the Ghana Police Service is to seek an order of prohibition in terms of the demonstration that they have evinced an intention to pursue.
Because we are in COVID-19?
Because of COVID-19, because there is an act of Parliament which imposes restrictions, Imposition of Restrictions Act, because there is also an EI issued pursuant to the Act, which also imposes a restriction on public gatherings and whatever.
Let me play devil's advocate here. So for a lot of our audience, a lot of the Fix the Country protesters, they would say that then there's some special treatment going on as far as this EI is concerned, because state actors were at Sir John, that's the former MPP General Secretary's funeral. That was allowed. People were allowed to gather. Why wouldn't they be allowed to gather?
Where people congregate with all respect, in the rural area, spontaneously, they see the president having shown up in the area, vice president having shown up in the area, even the chief justice also there, many actors were there, NDC MPs were there, and they see them show up and spontaneously they pour out at a funeral. That cannot be used as an excuse or a justification for a failure to apply the law. That on account of that, we should not apply the law.
Will the law be applied in that instance as well? For the governors who congregated without obeying some of these protocols. People are calling for that.
So those who are at the funeral, those government persons, I think all of them observed the social distancing protocol. Did you see the days, the high table? The days clearly was people observed it. And it was rather, with all respect, people in the rural area who poured out. And people in the rural area, I mean, so if you can identify them and all, the police people ought to do the investigation.
You mentioned Martin Amidu, who has sat in this office that you sit in today. He's been there before under the NDC administration. And yes, you talked about his harsh criticism against you personally. What's your relationship like with him?
Professional. When he was special prosecutor, I used to visit him, and he knows it. And he actually used to say much of the time that I was the only person from this ministry who used to visit him. And that is it. I mean, I have nothing against him. If he
so that appears cordial. Is it still cordial as we speak?
I've not met him anywhere at all.
Okay.
And there's no basis for a breach of that cordiality. If he has breached the cordiality, it's really entirely up to him. What I can say is that when the office was threatened by a legal suit, his own status as a special prosecutor was threatened by a legal suit. Dr. Dominic Ayini instituted an action against the Attorney General and himself. I rather defended him to the best of my ability, and my defense was actually upheld by the Supreme Court, and that resulted in him continuing as special prosecutor. So in a way, I'm responsible for his being special prosecutor, which he so much touts about, and that is fine. And
things turn out this way, where he's the one sort of championing your criticism.
But criticism for what? So that's really what you ought to take account of. The article that he wrote, very empty. Criticism for what? What did he say that I had done? That he had, Daily Guide had written a story about him. And then he says the Attorney General is behind it. It's totally spurious and speculative, conjectural, and everybody saw it. And if you observe the comments about the article, I think it spoke for.
Why was your reaction silence?
Because there was nothing to respond to, and I still have not responded to it. I would not take, if I were to take him on, clearly, I mean, there are all manner of actions open to me, because really what he did was baseless. But I'm saying that I'll leave it at that, and that's it.
Let me ask a difficult question. When people tag you as...
And I remember hitherto, he had also filed an application in the Supreme Court compelling the then Attorney General to institute certain proceedings in respect to the Waterville matter. Again, he had no basis, and I fought the matter to the best of my ability. And again, my defense of the action was upheld by the Supreme Court, and his action was dismissed. That is all.
So my difficult question is about you being tagged, including Mr. Martin Amidu, as young and inexperienced. How much pressure does that put on you? You're a young man in your 40s holding the office, Attorney General's office. How much pressure does that put on you, and how do you react to such commentary?
I don't know. I think that question perhaps ought to be addressed to Mr. Martin Amidu, because he was very old and supposedly experienced, and he served as Attorney General for only 11 months. So you ought to ask him. Maybe there was pressure on him. That is why he said for only 11 months.
Wow. Okay. That's a shade. That's a big shade.
But it's not 7 months. That's the record. 11 months.
Okay, very well. I want us to talk about another case where we felt your presence a bit. This is the alleged murder in Kaswa, the murder of alleged murder of a 10-year-old boy by teenagers. So maybe a bit of education is what really we're looking at. The last time in court, what happened was that your office advised that they be charged with conspiracy to murder and murder. Can you tell us why? And this question is because one of them is 16 years.
Yes, one of them is 16 years, the other is 18 years.
Yes.
And very unfortunate, gruesome murder. Really, the fact of the matter, I mean, this is a kind of situation that no parent, no adult would wish for his son or daughter. The two children, apparently, in a bid to make money, gone to see a Juju man who had said they should bring something plus human sacrifice. So they lured their friend into this house, club his head, and kill him instantly. Very gruesome. So I feel that is an action that the society ought to show the necessary revulsion for, and the Attorney General ought to take an interest in such prosecution. It's not just about the high-flying matters of the day or the political case or constitutional matters in court. It is about ensuring that justice is administered to all manner of persons. And I feel the only way that justice could be efficiently administered is definitely according to law. It's not just justice being administered in a way that somebody desires. It's just according to law. And there's a special law, Juvenile Justice Act, which lays out certain provisions regarding the trial of juveniles. And that law also stipulates timelines for the doing of certain things, especially prosecution, collateral prosecution, and how even the ages of the children could be established. And I felt that the police, if they were not guided properly, may perhaps screw the matter up by not doing things according to law and all that. So I decided to take the initiative by writing to the police, setting out the procedure that they ought to adhere to and all. And by the grace of God, so far, they have adhered to a procedure. The docket was referred to us for advice. Promptly, we examined the docket, offered advice to them, and directed that they should level the offenses that we indicated against them, murder and conspiracy to commit murder. And that will be done.
So what happens to the one who is 16 years?
So because one is a juvenile, the trial will be in a juvenile court. No, not in a juvenile, it's a court of summary judicial.
Okay.
And when the court of summary judicial implies that there will not be the need for bail of indictment. The normal trial process for murder involves preparation of a bill of indictment, committer of the person for trial, and what's before the actual trial in the High Court. In this case, the law says that if the person involved in the commission of the crime, and the crime involves is one that the punishment is death, should be tried in the court of summary judicial. And upon conviction, the person will be sentenced in a juvenile court. So I think that's and the trial ought to occur within 6 months. Yeah. So we make sure that the due process will be followed and the trial will be conducted expeditiously.
Okay. Something I want to bring to your attention, and which really a lot of Ghanaians would allude to experiencing it before. I'm sure across the continent, and it will be related to what black Americans will also talk about, the kind of brutality or the encounters they get from the police. There are instances where there's brutal force used by the police. Sometimes there's no cause. Sometimes, yes, drivers will be reckless or they won't do the right thing. What kind of advice do you have for the police administration in that instance where we have brutalities happening and people are sitting?
I mean, yes, the general phenomenon of indiscipline in many regards, galamsey, reckless driving, indiscipline on the streets, and all, is really of concern to me. And I've actually commenced, it's actually just, it's about to be formalized, and I'll formalize it in no time. A dialogue between myself, the Honorable Chief Justice, the Minister for Lands and Natural Resources, the Minister for Transport. I'll initiate, send them letters in that regard to start some consultative processes and all. And that will actually lead to the institution of more or less a permanent committee which we are addressing such issues. The committee will be made up of representatives from all these high-level persons and all. So it's just one of the means to address it. But I think that is very serious. One person says that if you go to any country, you want to see whether the people are disciplined, just look at the streets. And really, in Ghana, I think our story that is not sound at all. Some
legal minds talk about a bill, the consideration of a bill where there will be compensation for people or citizens who are wrongly detained, arrested, and prosecuted in such instances. What do you say to
Well, the Constitution has provisions on that. If a person has been wrongly convicted, after the acquittal, the person can apply for compensation. The Supreme Court is vested with the jurisdiction to determine such compensation. No, in fact, recently we dealt with a matter like that. So already there's legal or sufficient legal provision for such a situation.
Okay, and because you touched on the Galamsey fight, I just want an update on the Galamsey prosecutions. Remember the information minister talked about 5 cases pending. Yes, so what update?
Yeah, sure. I think that that's also one of the part of the mischief that was being leveled. I was compelled to go instantly on Joy FM because we actually hosting this program, Newsfire, on Saturday. They alleged people had been arrested, but there's no prosecution. People have had their equipment burnt. I said straight away that there were actually about 50 people, no, 46 at that time, 46 people on trial. Okay. And that arrests were being done daily. And since then, the number has actually appreciated. I think, if my memory serves me right, over 68 or 70 people are on trial for various illegal mining offenses. That is only since May, just since May. And it involves many Chinese people, about maybe over 25 Chinese people. And we're enforcing the laws freely. And it's important to place on record that our administration, again, is the one which initiated the process for an amendment of the minerals and mining offenses, whereby now, if a foreigner is caught in illegal mining, that foreigner will not be subject to deportation, that foreigner will be tried, and the person will be compelled to serve his sentence here. It was pursuant to amendment effected in 2019. Okay. So that is being followed. And there are many trials relating to the people who are engaged in illegal mining in Subin, Asakragwa, Enchi, somewhere in the eastern region, and all the alleged security operatives who indeed were not security operatives, but represented themselves as such. They're also being tried, 31 of them, and all. So the Galamsey offenses have been tried. Has
the president said that if anybody was displeased about the burning of excavators, they should go to court? Is anybody, do you have any update on that? Is anybody going to court?
Not to my knowledge, but I think it is important to place on record that I inherited a case and a judgment debt that I inherited about last year or so. Apparently, a person had judgment granted in his favor by the High Court of Kumasi. Okay. I was totally unaware. Aden Randabi of Metro TV was the one who, on the Joy FM program, drew my attention to it. Subsequently, I came to office on Monday, and I found I called for the relevant information from the region in Kumasi, and I got it. $50 million awarded by the High Court. Again, our attempt to have it set aside, even though the time for appeal had elapsed, just like the GPGC matter. So, and if I do my best, I think that the media should rather applaud it rather than...
Why not?
Yes, but so why didn't I applaud my effort to go the extra mile to set aside the GPGC one? Because really, Ghana was out of time, and I had me appointed Attorney General straight away. I rather engaged or moved for the state to go the extra mile. And that is what we need as public officers.
All the best with that. And of course, if you bring the good news, I don't think the media will hide it.
So when the challenge fails, then there is what a trumpeting of the failure.
No. I mean, we'll talk about the failures. We'll talk about the good as well. My last question really is, what's happened to the 10 people arrested for what allegedly plotting a coup against the president?
Yeah. Sure. So the trial is on. Even today, we were in court. Earlier today, our second witness testified. I led him in evidence in chief. He concluded his evidence in chief. He's under cross-examination by counsel for the accused. Is it again part of the Attorney General's interference or being hands-on unnecessarily?
Depends on the lenses you are wearing. But yes, you will get people who would appreciate the hands-on approach, and some would see it as interference. But I guess the results is what will determine whether or not it was worth it. But okay, Minister, thank you so much for your time here on Good Afternoon Ghana. We are grateful for letting us invade your office, turn things around a bit.
Pleasure.
We wish you all the best, and we'll stay in touch to report both the good and the bad.
Freedom of the media.
Yes. Well, this has been Good Afternoon Ghana with Attorney General and Minister for Justice Godfred Dame. Thank you for watching. I'm Francisca Kakra-Forsen. Bye-bye.
Metro TV, insightful and inspiring moments.
Yenim say whoop football pa. And Nuntina High Sense as sponsor Euro 2020. Edia Mauno. Nisa Suntina Yatiti TV so say who? Edia Mauno. A High Sense Euro 2020 TV Super Promo. Kahoe kwajo brand new High Sense TV and nebuo dafo. Pictures near clear na color near deep. Sound quality this so dear one it here. High Sense TV so dear entry power. About down one access you are. Akona utusa barefoot. Everything 18th June, I copy 11th July. A High Sense Euro 2020 TV Super Promo. Emma Refisa, High Sense and Kwan, Emma 5 years warranty. A High Sense Euro 2020 TV Super Promo. A Kosovo High Sense showrooms, I want Ghana for Nanina. What you dear Nansenya? High Sense, everyday prices for everyday people. High Sense, official sponsor at the Euro 2020.
Masa, jam Maria, I'm kind of coffee. I am no more budget born jam. Have a beer, you can be
HD logo the bottom. When you say HD local channels na mo. And so pictures near clear. They are 5 times better. As in other channels that could be sure. So what I mention when I'm right away. Oh, what the pictures. What a picture. What do 8D plus decoder or multi TV and now Electroland agent PR natural local channels now HD the here is better *879# numbers from Kubo box and now the advert 80 channels na.
Get an HD Plus decoder from now till the 9th of August for just 89.99 Ghana cedis and enjoy 3 months free subscription. Enjoy all the excitement and live sports action in the HD Plus Air Bosso Philly promo. Promo lasts from 7th June to 9th August 2021. Visit hd-plus.com.gh or call 024-243-9872 for more info.
Half a nose for good things.
Metro TV, insightful and inspiring moments.